You want to hear about a sneaky tactic the defense used in this particular medical malpractice case? Come join me on this walk through the neighborhood as I tell you exactly what they did and why it was so sneaky. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, my client sued her orthopedist, claiming that he performed an improper foot surgery on her and now suffered significant harm and injury. During the course of her lawsuit, she appeared for questioning in a process known as a deposition, where the attorney who represented the orthopedist had a chance to question her. Now, there was no jury present, there was no judge present. This took place in our office. During the course of questioning, she was asked lots of questions about what happened to her, what conversations she had, and importantly, what problems and injuries she had now as a result of this improper medical care. So now my client began to explain to the defense attorney all the things that she was unable to do, and all the things she had difficulty doing, including walking, running, jogging, and various other sports activities that she was able to engage in before she underwent this surgery. Okay, so now you would think that the defense attorney would accept what she has to say as truth. Well, guess what? They don't have to do that. They can listen to what she has to say, but then they are now going to verify, to confirm exactly what she has to say. So you might be thinking, okay, how do they do that? How do they try and verify whether what my client is saying is actually true? How do they verify the extent of her injuries, that she cannot do certain things now or has difficulty doing things such as playing sports? I'll tell you how they do it. They do it by getting copies of her medical records. And anytime someone brings a medical malpractice case or an accident case, and now they are claiming they suffered physical injury because of someone else's carelessness, the defense attorney has a legal right to go ahead and get copies of their records. We, as their attorney, have an obligation to provide the defense with copies of the records, and they will also go ahead and get the records on their own. Why? Because they don't exactly trust us, so they want to get the records directly from the source. In addition to that, they are also going to do an internet search and scour your social media profile to see whether or not you have posted anything online, to see if it's inconsistent. So if you said you can't go rock climbing and now they find pictures of you on Facebook going rock climbing, you've got a problem, my friend. And then what else will they do? Many times the defense will hire a private investigator to go ahead and try and catch you doing certain things you claim you couldn't do and get you on hidden video, surveillance video, doing those types of activities that you claim you couldn't do. So now, we had provided the defense attorney with a list of the allegations in this particular case in a document called the Bill of Particulars. And that basically is a list of allegations together with a list of all the injuries we were claiming in her case. This way the defense attorney knows exactly what the allegations are and they know exactly what injuries she's claiming. So now my client goes ahead and testifies and answers questions about the problems and injuries she has because of this doctor's carelessness. And you would think that's the end of it. She's done after a long day of being questioned, a full day of being questioned, and now she goes home. All right, a few weeks later, I get a package in the mail. And what is it? It's a CD. It's a disc. It comes from the defense lawyer in my client's case with a little letter that says, hey, Mr. Oginski, I just want to let you know, enclosed is a disc of surveillance video that we have of your client. Enjoy. Okay, so what do I do now? The first thing I do is I grab some popcorn, I pop it into my computer, and now I sit down to watch. Because now I want to see what it is that they've gotten on video. And what do I see? I see that a surveillance video was done of my client when? The moment she walked out of my office after testifying in her pretrial deposition. That was the sneaky tactic. So here they had gotten my client to go ahead and testify and swear under oath that here are the problems that she had, here are the difficulties that she had, here are the things she was no longer able to do, and before she had a chance to actually go home, they wanted to catch her in the act of leaving my office, walking to her car, getting in her car, following her home, and now getting out and doing whatever it is that she was doing. And that's exactly what was seen on the video. But there was something else on the video that troubled me. You want to know what it was? My client claimed that she walked with a limp. She said that even though she didn't use a cane or a walker to walk, she had a limp. And she explained very clearly why she had a limp. She said, listen, every time I walk, after a period of time, my foot swells up, causing me pain. And then what happens is, in order to offset that pain, I try and shift my weight to the other side of my body. And doctors call that an antalgic gait. And what that does is it shifts and moves your body to one side. So now your body favors the opposite side, causing problems. So now when they saw her on video leaving my office, they caught her walking down the steps. They caught her leaving the building. They caught her walking down the street to her car. And you know what? There was no limp. And the defense attorney was going to try and use that absence of any limp to show that she had lied, to show that she was contradicting herself by claiming first that she was unable to do those things and that she had a limp every time she walked. And now here she is walking down the street out of my office and she had no limp. And you know what? It didn't bother me that much. Why? Because it was not inconsistent with what she had said. She said it only happened after standing on her feet for quite a period of time, and then as she continued to walk, the pain caused her to shift and now transfer it over to her other side of her body, causing her to then limp. So why was this such a sneaky tactic for the defense to use? It was pretty sneaky because, number one, she didn't expect that this was going to happen. Number two, I didn't expect that they'd do it the moment she walked out of my office. What I have seen in the past is when someone is claiming that they can't do certain physical activities, the defense may hire a private investigator to get you on surveillance video before you testify, then have the witness testify, swear to tell the truth about things that she can and can't do, and then try and get her on video after the deposition. But the fact that they got her literally walking out of my office meant that they were waiting for her. They had to wait all day for her outside to try and identify who she was, because they only had a photograph of her, and then catch her as she's coming out the door, and then catch her going down the street, getting into her car, and then going about the rest of her day. So why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases, in these accident cases, every single day in New York. You know, I recognize that you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you have not yet started a lawsuit but are thinking of doing so, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.